W. Davis. I've practiced law in California for nearly 40 years, and a significant part of my work has been in juvenile dependency and CPS cases. Today, I want to talk about something that many parents don't realize they have a legal right to, and that is having meaningful input in their family reunification plan. If CPS has removed your child and you've been ordered into services, this video is important. Because too often parents are handed a reunification plan as if it's non-negotiable, as if it's already decided, when that's not what the law requires. So let's talk about what the California Rules of Court actually say. A family reunification plan is supposed to be a roadmap, not a punishment. Its purpose is simple: to address the issues that led to court involvement and to safely reunify families as quickly as possible. The problem is, in practice, many plans are overbroad, generic, not tailored to the family, not connected to the actual allegations, and created without meaningful parent input. That's not just unfair, it's legally problematic. The California Rules of Court make it clear that reunification services must be reasonable, appropriate, and tailored to the family. While the rules don't use casual language like parents get to design the plan, they require parent involvement and individualized planning. Rule 5.695 emphasizes that services must be designed to eliminate the conditions that brought the child within the court's jurisdiction. Services must be appropriate to the family's circumstances. The plan must be realistic and achievable. A plan that ignores the parent's circumstances, limitations, or existing services is not reasonable. And that's where parent input becomes legally required. Courts have repeatedly held that reunification services must be individualized, not cookie cutter, not punitive, directly related to the sustained allegations. If CPS creates a plan without listening to the parent, the plan often includes unnecessary services, duplicate services already completed, sets parents up for failure, or delays reunification without justification. A reunification plan that is not informed by the parent's situation is often not reasonable, and unreasonable services can be challenged in court. Parent input does not mean CPS has to agree with everything you say, but it does mean CPS should ask about your work schedule, consider transportation limitations, account for language barriers, review prior services you've already completed, consider cultural, medical, or mental health needs, tailor services to the actual findings in the case. For example, if the allegation is substance abuse, the plan should focus on substance-related services, not unrelated parenting classes piled on without explanation. If the allegation is domestic violence, the plan should be targeted, not a blanket list of unrelated requirements. When CPS ignores parent input, courts can find services were unreasonable, the department failed its obligations, the reunification period was unfairly compromised. This becomes critically important at 6-month review hearings, 12-month review hearings, contested hearings on reasonable services. Parents often lose reunification not because they were unwilling, but because the plan was unworkable from the start. This is where a knowledgeable attorney matters. Your lawyer can object to unreasonable services, argue that the plan is not tailored, request modification of services, preserve the issue for appeal, force CPS to explain why each service is necessary. If a reunification plan was created without your input, that is something your attorney should raise early, not months later. If you're currently in a CPS case, ask yourself, was I asked about my availability? Was I asked about services I already completed? Does this plan actually match the allegations? Is this plan realistic for my life circumstances? If the answer is no, that's a red flag. Document your concerns. Communicate them through your attorney. Ask the court to require CPS to tailor the plan properly. Family reunification plans are not meant to be automatic checklists. They are supposed to be collaborative, individualized, and fair. The California Rules of Court require services that actually help families reunify, not services that just look good on paper. Your voice matters, your circumstances matter, and the law supports that. If you're dealing with CPS and need help understanding or challenging your reunification plan, consult with an attorney who understands juvenile dependency law. Call us for consultation at 888-888-6582. Thank you for watching, and I'll see you in the next video.
vivid picture is encrypted in your mind as the critics get in line like they're witnessing a crime. But then you notice there's a shiver in your spine from the feelings of discontentment and bitterness combined. Heartbroken when you listen to the judges, another kid's innocence corrupted. And if you go against it, it's destructive. Consider this predicament the toughest, but we believe in a system fit for justice. Child Protective Services only pretends to save it. The one solution for this is worthy of instant praises. 30 years of experience with relentless cases. Allow me to introduce them. This is Vincent Davis, defending you when they don't think a mother fits the role. Is it juvenile dependency or government control? Observe the pain in their eyes. It's time for us to realize we are the last